The Kerala High Court on Thursday, January the 19th, 2017 in Amusement vs MP Muhammad Ali has held that when complainant has the knowledge that the addressee left the place in search of a job outside India and knowing this fact, he sent notice and it was returned as addressee left India, there is no proper service of notice. The Honourable Mr. Justice P.D. Rajan directed the learned magistrate to take fresh evidence with regard to the service of notice and dispose of the matter as per law. In this case, the revision petitioner was working abroad when notice under Section 138(b) of the NI Act was issued at his residence, but he never evaded from the receipt of notice. Both courts failed to appreciate that position and convicted the accused. Therefore, the conviction and sentence passed by the Judicial First-Class Magistrate Court, which was modified by the learned Additional Sessions Judge, are set aside. The matter is remitted to the trial court for fresh consideration. No evidence has been adduced by the complainant with regard to the knowledge of the accused about notice. If the registered notice as contemplated under Section 138(b) of the NI Act was issued by the complainant, but it was returned with endorsement addressee left India, and the complainant at the time of issuance of notice knew that the accused went in search of job in a foreign country, there is no deliberate avoidance of notice and it is presumed that there is no notice under Section 138(b) and no presumption of service can be drawn against the drawer, the bench said. In this case, the complainant knew that the accused went abroad in search of job and he is not available in his residence. Even then, he issued a notice under SCC 138(b) of the NI Act. The complainant has no case that the accused deliberately evaded from his residence in order to avoid service of notice. The court observed that if the service of notice is fraudulently refused or avoided by the accused in an unscrupulous manner, that is a matter of evidence, and that fact can be proved on the basis of evidence. If complainant is able to prove that the drawer of the check knew about the notice and deliberately evaded from the premises making a false endorsement, it will defeat the process of law, and in such situation the court shall presume that there was proper service of notice. The notice could not be served on the addressee on the ground of his non-availability at the time of delivery, or the house is remaining locked on account of his non-availability in the station or in India, or he has gone elsewhere permanently, etc. In each such cases it means that there has been no service of notice. However, if the addressee refuses the notice, it may be presumed that the notice have been properly served. Each question with regard to the service of notice has to be answered by reference to the facts of the case, and no rule of universal application can be laid down in all cases when notice is not served on account of non-availability of the addressee in the given address, the ruling said.